So what we're going to do, we think, is Jane is going to tell you a little bit about US fair use law. And she's going to give you a general introduction and then talk specifically about some examples concerning appropriation art. And then I will try and explain something about the new fair dealing by way of quotation defense and examine the extent to which the examples she's given are covered, and we will pick a specific, we've chosen a specific test case to examine, which was a case that was settled in the United States. Jane will then resume and talk about the Google Books decision and some other fair use case law in the United States, and I will then respond by saying whether I think those would be covered by the fair quotation exception. And finally, we'll finish with a few words on data mining, and that'll be at about 10:30.
We've been cutting slides mercilessly. And I should say that this presentation is prompted by two things. One is the very recent Google Books decision, which has received an immense amount of coverage in the United States, and I imagine you've heard about it here in England and in the EU as well. I can still say England and the EU for the moment. Also, because of the new quotation right in the UK law, it's interesting to compare the scope and interpretation of the fair use doctrine in the United States with the UK provision. I should say that what you have on the screen, which is the text of the fair use doctrine as codified by Congress in the 1976 Copyright Act, which is still our Copyright Act, although the Copyright Act has been amended a lot in the intervening years. This is a codification of a judge-made doctrine which goes back to the mid-19th century in the United States, but it really originates back in Britain in the 18th century with the so-called fair abridgment doctrine, in which the English courts recognized that the copyright is not an absolute right, and there are circumstances in which the right of the author or proprietor to prevent the reproduction and selling of books has to yield to some public interest concerns, particularly where the second author has improved on or built upon the prior work. And one of the well-known instances of this doctrine involved corrections to a book of roadmaps, so one really wouldn't want the proprietor to prevent the more accurate versions from being disseminated. And in general, I believe it was Lord Mansfield, Bill will correct me, said one must not put manacles upon science. So copyright should not be a tool for the suppression of learning. It should be a tool for the advancement of learning. That notion has also been adopted in the United States, where we didn't have a fair abridgment doctrine as such, at least not as elaborated in the UK. Indeed, there was even some resistance to the fair abridgment doctrine because there was a perception that the abridgments were not so fair and they were competing with the full-length version. So that the American jurist who is credited with creating the antecedent to the fair use doctrine in the United States, Justice Story, was actually not a friend of fair abridgment, because Justice Story wrote a lot of very lengthy treatises, and he didn't really appreciate the unauthorized dissemination of the single volume version by somebody else of his treatise. So in his enunciation of the considerations that courts should take into account, he distinguishes what he called the facile use of the scissors from a true labor of creating a new work which borrows reasonably from a previous work without prejudicing the sales of the borrowed work. Those notions found their way into the United States Fair Use Doctrine as codified by Congress in 1976. And so you see the preamble, our Fair Use Doctrine comes in two pieces. There's a preamble, and then there's the operative language, the factors courts are to take into consideration. Now, conceptually, fair use is considered not an infringement of copyright, as the statute says. Procedurally, the plaintiff has to show that the work is protectable by the copyright law, that it was copied, that what was copied was copyrightable expression, not merely information or the quote idea of the plaintiff's work. But after that, the burden shifts to the defendant, who may, in appropriate circumstances, prove that the use is a fair use, and if so, it's not an infringement of copyright. The preamble to the Fair Use Doctrine contains a number of examples of the sorts of uses which traditionally can be considered fair uses. Now, I'm deliberately being mushy in the way I am saying this because the Fair Use Doctrine is not a closed list of exceptions. Unlike, for example, the European Union's Information Society Directive, which lists a bunch of generally optional exceptions, and then the question is, does your use fit into one of those exceptions or not? In the Fair Use Doctrine, the preamble serves to give you an overall flavor of the sorts of things that can be considered to be fair use, but it is not sufficient to say, my purpose in copying from your work was criticism, I win, right? You have to nonetheless carry your burden of persuasion on the four factors, which are on the next slide. But I put these up here because although we have no specific limitation as to purpose, so if your use is in the preamble, that doesn't mean that it's a fair use. If your use is not in the preamble, that doesn't mean it's not a fair use. Nonetheless, if you look at the examples that are given, they, with the exception of multiple copies for classroom use, all involve what one might call productive uses of the previous work. In other words, they build on the previous work in order to create a new work of authorship. And that's kind of the classic fair use situation. Author number 2 borrows from author number 1 to create a new work of authorship. We will see that that paradigm has evolved a lot in recent years. So the statute says that the courts shall take into account these factors. The purpose and character of the use, so it doesn't say what the purpose has to be, but what the purpose is, will weigh more or less heavily in the balance. Particularly, at least originally, there was something of a dichotomy between commercial uses and nonprofit educational purposes, with the latter being favored and the former being disfavored. I would say that that is less true today, as we will see. And moreover, the courts have taken the factor, the purpose and character of the use, and have asked whether the nature of the use that the defendant is making is, quote, transformative. And we will talk a lot more about transformative when we get to some specific examples. But the rhetoric and debate over transformative use really goes to the first fair use factor. The second fair use factor is one that courts routinely ignore today. I think the reason for that is that it doesn't really make a lot of sense to say, for example, that works of fiction are more insulated against fair use than works of scholarship and research. Sometimes courts say that, but that wouldn't explain why, for example, parody, which is not an explicit exception, but which our courts have recognized as the kind of purpose that can be a fair use. Parodies are generally works of fiction and entertainment, not too many parodies of scholarly tomes. So the distinction fact-fiction, I think, doesn't really hold up. And I won't say anything more about the second factor. Of course, courts don't say anything more about the second factor. The third factor, sometimes this is characterized as, did you take more than you needed to take for your purpose? That will echo when Lionel talks about the quotation right. Although the third factor is stated in terms of the portion of used in relation to the copyrighted work as a whole, how much did you take from the plaintiff's work, courts also tend to look at how much of the defendant's work consists of what it borrowed from the plaintiff's work. So the more the defendant's work is dependent on, or one might say parasitic on the plaintiff's work, the less likely that it might be a fair use. And finally, what used to be considered the most important factor, the effect of the use upon the potential market for or value of the copyrighted work. This goes back to Justice Story. Was the object of the plaintiff's work superseded by the defendant's work? So does the defendant's work substitute for the market for plaintiff's work? The statute wisely says potential market, so anticipating that technology will bring along new markets, or business models will evolve that find new ways of exploiting works of authorship. So the inquiry into the substitution effect addresses not only does the defendant's copying from your work compete with the old way, the way your work used to be exploited. The courts should also be asking, does it compete with emerging ways that the work will be exploited? For example, in the Napster case, I assume that you remember Napster from the sands of time, an argument was made that Napster does not compete with sales of CDs. It was possible in 1999 to say that with a straight face. The judge said the evidence may be inconclusive as to whether Napster competes, whether those free unauthorized downloads compete with the sales of CDs, but that's the wrong question. The question is whether those free unauthorized downloads compete with the emerging market for paid downloads. And there, free versus paid would seem to be pretty head-on competition, so not fair use. Now, some of the more fringe issues in fair use. You have appropriation artists here as well, I assume. One of the most notorious practitioners of this form of art is Jeff Koons. And Jeff Koons got sued quite a while ago now, 1992, by a photographer named Art Rogers. Art Rogers is a kind of rank-and-file journeyman photographer who takes pictures that are sold on greeting cards and that kind of low art medium. And one of the pictures that he took was this image of a couple in Marin County with their litter of puppies. Jeff Koons created this sculpture from it called String of Puppies, and which he sold for a lot of money in high-end galleries in New York City. He got sued by Art Rogers, and he said, my work is a parody. And the court said, well, not really, because what are you parodying? No, a parody implies that the audience knows the work that you copied from. You can't really get the joke if the object is unknown. So Koons said, well, he wasn't really parodying the Art Rogers photograph, but he was parodying the banality of suburban life for which it stood. Right? So back to the couple in Marin County. Right? And the court was not really impressed with that. I thought, well, if you want to parody something else, you don't need to copy poor Art Rogers. It didn't help that Koons took Art Rogers' greeting card, obliterated the copyright notice, sent it to some craftsmen in Italy and said, I want you to make a sculpture that looks as much like this picture as possible. Those are the kinds of facts that judges don't often like. But this case was an early marker not favoring appropriation art, at least not appropriation art by bad boys. But things evolved, and after the coining of the term transformative use, which was made up by a very distinguished judge named Pierre Laval, who sits in the Second Circuit and incidentally is the judge who authored the Google Books opinion 2 weeks ago, the court's treatment of fair use began to expand. The Supreme Court endorsed the term transformative use, a use which gives new meaning or new message to the copied material, endorsed that formulation in a case called Campbell against Acuff Rose 2 years after the String of Puppies case. Campbell and Acuff Rose was a musical parody. The underlying song was Pretty Woman by Roy Orbison, which you may remember from the very treacly movie with Julia Roberts and Richard Gere. Maybe nobody remembers that movie anymore. And anyway, that song was constantly on the soundtrack. It was on the soundtrack of the movie. It was parodied by a rap group called Two Live Crew, which substituted some fairly raunchy lyrics and also deliberately distorted the melody. It was the first time in which the Supreme Court recognized that parody can be fair use, although the court didn't finally rule that that particular work was a fair use parody because it remanded on the question of whether they copied too much, where they copied more than they needed for the parodistic purpose, and then the case settled. But transformative use was now blessed by the Supreme Court as a mode of analysis. So back goes Jeff Koons to court, sued this time by a photographer named Andrea Blanche, who was a fashion photographer, and her picture is the feet in the sandals that you see to the left, which was incorporated by Jeff Koons in this kind of collage thing called Niagara, because somewhere in there is an image of Niagara Falls, along with a lot of, if you look all the way to the left in the background, I think you'll see Niagara Falls. But collaged with a lot of pictures of fast food and other women's legs. So it wasn't quite as much of an appropriation as String of Puppies, which was a translation of the photograph, a 2D photograph into a 3D sculpture. Here there's lots of other stuff. But Jeff Koons learned how to talk the talk between the first case and the second case, and he had an elaborate explanation for what he was doing and what was the new message that he was conveying, and that what he was decontextualizing the advertising and sexualized context of the original Andrea Blanche picture and putting it in this other picture, which says something, I'm not sure what, about mass consumer society in the United States. It was all, really, it read like somebody's art criticism college thesis. And the Second Circuit said it's fair use. It's a transformative use, even though he didn't even pretend that he was parodying the Andrea Blanche photo. He was just giving it a new meaning and a new message by putting it in this completely different context. So fair use. this case is fairly notorious. We have another appropriation artist named Richard Prince, who is known for taking other people's stuff. In a sense, part of his artistic message is that he takes other people's stuff. The photograph that you see on the left is by a photojournalist named Patrick Carreau, who lived for several years with the Rastafarians in Jamaica and took a series of very beautiful, some would say prettified, portraits of the Rastafarians. Richard Prince did a show in which he took the images from Patrick Carreau's book and treated them with more or less additions. The one that you see here, he simply added a guitar and kind of painted over the facial features. Other pictures show more transformation of the original images. So you have the Carreau images on the top, and then you see how they've been reworked and collaged in the work on the bottom. Richard Prince sold these paintings, a series of paintings called Canal Zone, for many, many millions of dollars. Patrick Carreau's book, Yes, Rasta, is out of print. Patrick Carreau sued, and even though you might say, gee, this seems very much like String of Puppies, the Second Circuit said that this was fair use because it was a transformative use, that the Carreau images have been changed. When at the district court level, when Prince argued transformative use, the district judge said, well, transformative use implies new meaning, new message. What's your message? And Prince says, my message is I didn't have a message. So district judges don't really like arrogant parties. I think it didn't help. But so she said, okay, no message, no transformation, not transformative. Goes up on appeal, by which point everybody in the art world has put in an amicus brief all about what the message of Prince's work is. I think the bottom line is, I'm an artist. So the Second Circuit said that he doesn't have to proclaim a message. It's obvious if you look at it that the pictures have been, that their meaning or message has been transformed, even if we don't have to discern a specific message. And here's where things get kind of interesting. Let's go back to those four factors. If we have a transformative use, that means that the use is operating in a different market from the market in which the plaintiff operates. So when you get to the fourth factor, the effect of the use upon the potential market for a value of the copyrighted work, there's no competition because these artists are operating in completely different worlds. Patrick Carreau is a photojournalist. Richard Prince is a very high-end denizen of the art world. The Second Circuit, even in an act of stunning irrelevance, as far as I'm concerned, included in its opinion the guest list from the gallery opening of Prince's show. And so if you want to know where Tom Cruise was that night, he was at the gallery opening. So right, A-list celebrities went to the gallery opening. Carreau can't pretend to play in that league. So since there's no, they're completely different markets. There's no deleterious effect on the market for Carreau's work. As we will see, this conflation of transformativeness, transformative work, transformative purpose, transformative market has begun to take over the U.S. fair use doctrine, so that where we used to have one factor, we used to have four factors, now we have one factor, and we'll see that in play when we get to Google Books. Here's just a summary of what I just said about transformative use. Okay, over to fair dealing.
So before October 2014, it would have been extremely difficult to argue that any of those kinds of cases were exempt from copyright infringement in the United Kingdom. As Jane explained, the United Kingdom has operated a closed list of exceptions, each of which was relatively narrowly defined. The broadest of the exceptions were fair dealing exceptions, and they were defined by way of specific purposes. Fair dealing for purposes of reporting current events, fair dealing for criticism or review of the work or of another work, fair dealing for research or private study. And that closed list appeared also to be reflected in the European harmonisation, such as it's been of the exceptions in the Information Society Directive, which has a list of exceptions that member states are permitted to have in Article 5.2 and 5.3 of the directive. Now, in 2010, David Cameron thought this position might need to be revisited, and he set up an inquiry headed by Ian Hargreaves, known as the Hargreaves Review. And one of the questions he asked Hargreaves to look at was whether the UK should adopt a fair use style defence. And the Hargreaves Review reported in 2011, he said, no, the UK can't adopt a fair use defence. It's actually not possible within the European law governing copyright. And apparently the only submission they'd had suggesting otherwise was from me, funnily enough. The government then proceeded to take advantage of the flexibilities that the Information Society provided by incorporating into UK law a bunch of other defences. And one of those defences is the newly introduced Section 31ZA, fair dealing by way of quotation. And what I want to suggest is that this fair dealing by way of quotation exception, in some respects, brings the United Kingdom much closer to the fair use law of the United States. But, as we'll see later on, the fair use law in the United States has moved on in a different sector, which it's very difficult to say is covered by the fair dealing by quotation defence. Now, how can the fair dealing by quotation defence be said suddenly to have brought this great expansion in flexibility of UK exceptions? Well, you can see there that copyright is not infringed where there is use of a quotation from the work, whether for criticism or review or otherwise, provided the work has been made available, the quotation is fair dealing, the extent of the quotation is no more than is required for the specific purpose, and the quotation is accompanied by sufficient acknowledgement. So the first requirement is there's a quotation, that it must be for criticism or review or otherwise, that the work be made available, that the quotation be fair, that the quotation be proportionate to the purpose, and that there be attribution. So those there are set out the 5 things. And the one that is the most important breakthrough here is that the fair dealing by way of quotation defence is for criticism or review or otherwise. Because previously, as I said, all the defences were limited by purpose. But criticism or review or otherwise might well allow the use of quotations for purposes other than criticism or review. So any good lawyer would ask, what is the breadth of that or otherwise? Are we just talking about similarly critical expressive uses? Or is it complete open season on quotation? And my argument is that, and maybe Jane will get to chip in later on to say she disagrees, but my argument is that it's open season, that quotation is permissible for any purpose. And why do I say that? Well, because the new exception is based on a provision within the Information Society Directive, Article 53D, and that in turn reflects a provision in international copyright law in the Berne Convention, Article 10.1 of the Berne Convention. And Article 10.1 of the Berne Convention is an exceptionally interesting provision because it creates a mandatory exception, an exception that all parties to the Berne Convention must apply in relation to Berne Convention works, because it says it shall be permissible to make quotations. And that's important because that means that the EU provision that on its face looks optional is not optional, and that what the Hargreaves Review and the government did when they implemented this was to implement their international law obligation. If you look at Article 10.1, you can see it says it shall be permissible to make quotations. It doesn't mention any limitations as to purpose at all. It just requires that there is a purpose, so that the use of the quotation is proportionate to the purpose of the user. But there is no limitation as to the kinds of purpose. So on a straightforward reading of Article 10, which is being implemented, that criticism or review or otherwise in the UK Act is completely open-ended. And that view is affirmed if you look at the travaux leading to Article 10, because it was introduced in the Stockholm revision in 1967, and at various points in the revision, people said we should limit the purposes and suggested some purposes that the quotation right should be limited to. And at every point it was objected that it was not possible to come up with an adequate list of purposes, and so the term should remain open-ended. So it had been initially proposed to limit to scientific, cultural, informatory and educational purposes, and it was said that that would not cover artistic purposes, and then later on another committee said what they wanted this to cover judicial purposes, political purposes, aesthetic purposes, purposes of entertainment. They didn't want it to be limited. And so what that means now is that subject to the other requirements, that the work has been made available, the use is proportionate, that there's attribution, and importantly, that it's in accordance with fair practices, any use of a quotation is now exempt from copyright liability. So, now what we want to do is to go through an example and see where that gets us. It moves us in the UK, I think, a lot closer to the United States, but there are still some troublesome points. So do you want to talk about the background to this, or? Yeah.
Right. Well, this is a case that's settled under a bit of a cloud, but the facts of the case are that the photograph you see on the left is a photograph taken by Associated Press reporter Manny Garcia at a news conference that then candidate Obama gave in 2008. And when the Obama campaign was looking for an inspirational political poster, they asked Shepard Fairey, who is an appropriation artist, to create an inspiring image. And so what Shepard Fairey did was he went on the internet and he found a picture and he downloaded the picture. His attitude seemed to be, well, if it's out there on the internet, then I can use it. Without attribution, without permission, without payment. So he downloaded the picture, he Warholized it, he superimposed the word hope, right? This was the slogan of Obama in 2008 in happier times. And that was an iconic poster. It was very, very effective. Then Fairey gets a letter from the Associated Press and says, that's our photographer, that's our image. We don't want to stop you from making this poster, but we do think that you should pay us for it. And then Shepard Fairey, instead of entering into discussions about taking a license, initiated a declaratory judgment action. What's that called in the procedure here?
Summary judgment?
No, declaratory judgments, where somebody who to avoid being the defendant, you beat the plaintiff to the courthouse door. So you seek a judgment of non-infringement.
Oh, right. So like a declaration of non-infringement, yeah.
Okay. So Fairey, rather than being on the defendant's side of the V, he initiates the action for a declaration of non-infringement. But then things started to go wrong because he also said that he didn't actually use the photograph that you saw, that he used another photograph. But it turned out in the process of discovery that not only was that wrong, but he tried to destroy the evidence in his computer of the actual photograph. The judge didn't like that and threatened him with contempt of court, criminal contempt. And the case settled. So we never got a ruling on the argument that this was that his use of the image was fair use. There was also a question in the case whether that image whether Fairey took any copyrightable expression from the original photograph, because that's Obama's face. It was Obama. Posed himself. It was just the way he was sitting. Much of the lighting has been stripped out by the Warholization, and so one might say that the copyright in a photograph being thin to start with, the Shepard Fairey didn't take any copyrightable expression as opposed to true fact from the underlying photo. This sparked some really interesting submissions by photojournalists trying to explain how what they do is authorship. But we're not going to talk about that here. You can read the papers in the case. It's very interesting. Assuming that the copyrightable expression was taken, then the next question is it fair use? And the argument being this is for political commentary, although it's not really commenting on the photograph, right? This is the problem about copying from the work, the underlying work, in order to say something about the underlying work, as opposed to using the underlying work as a platform to talk about something else. That was a distinction that used to matter in U.S. copyright law. I don't think it matters anymore. At the time the case was filed, it probably still mattered. If this case were coming up today, given the rather broad concept of transformative use, he might have a pretty strong argument that he is giving new meaning or message to the original image. There is, however, a little problem with the fourth factor, the substitutional effect, because the business of the Associated Press is to license the images of its photographer for all kinds of use, not just for reproduction in journals, but for just about any iteration or commercial iteration of the photograph is something that they license. So there would have been an interesting discussion of substitutional effect in that case. Be it as it may, we don't have an answer in that particular case, but it's one that I think would test the limits today of, if there are limits, of the transformative use doctrine. As for how this would come out in the UK.
So, the first question we need to consider is whether this is a quotation at all. And when we think about the term quotation, often we summon up very quickly the image of a textual quotation. So, where a small component from a long work is taken from that text and replicated in a longer text that comments on the work. And if you took that and you tried to come up with a definition of a quotation from that typical use, you might impose as conditions of quotation that there be replication, that it be a small part of the work from which it's taken, and that it involves some kind of referencing back. And if any of those are necessary conditions for quotation, it's pretty hard to say that Shepard's Faeries work is a quotation. But I don't think that any of these are necessary conditions. I think that if you think more carefully about the notion of quotation, and you think about its use in contexts outside of printed text, you can see that the term quotation is much more open. So does quotation require, in the way in which it's ordinarily used, replication rather than reuse or paraphrase or summary or whatever it is that you might want to call what Shepard's Faerie has done? I think the answer is obviously no. It doesn't require replication. If you look at art scholarship on, say, Déjeuner sur l'herbe, Manet's great masterpiece, that took an image from an engraving by Raimondi, which in turn had come from a Raphael painting. That image is reworked in Manet's Déjeuner sur l'herbe, and yet art scholarship refers to it over and over again as quotation. If you look at the way quotation is used, the kinds of practices it is describing, replication is not a requirement. Think about the use of the term quotation in relation to film. Probably the most famous example of quotation in film is in Brian De Palma's The Untouchables, where there is a version of a scene from Eisenstein's The Battleship Potemkin. The Odessa Steppes scene, the famous scene where the Cossacks attack the people on the then known as the Richelieu Steppes in Odessa, who are supporting the mutiny by the naval officers in the Battleship Potemkin. And in that scene, there are all sorts of famous things, including the pram falling, teetering on the top of the steps, falling down. And all these things are repeated in Brian De Palma's shootout at Union Station in Chicago between the law officers and the mafia, Al Capone's mob, in the film The Untouchables. That is referred to over and over again in the film literature as quotation. Quotation in its ordinary meaning does not require replication. So I think that is not a requirement when we think about how the term quotation is used. Does quotation require use of only a small part rather than the whole, as Shepard Faerie seems to have done here? Well, one can question whether he's used the whole. There's lots of bits in Shepard Faerie's version that aren't in, lots of bits in the original version that aren't in Shepard Faerie's version. And as Jane says, you could even ask the question whether any of the originality of the photographer had actually been reproduced. But I think that it is not a necessary component of the notion of quotation, used as a matter of ordinary language, that it be of a small part. We all know of cases where, situations where people quote extensively, or quote at length, or quote in full. And in those circumstances, the term quotation is being used to describe use in relation to quite sizable parts. And in fact, that view is backed up by the Travaux, but I crossed out in our decimation of the slides in advance of this meeting, I crossed out all the Travaux provisions that support that view. Then the third question is whether quotation requires reference back. In some jurisprudence on quotation, implementing Article 10 of Berne, there is a view that quotation, as in text, requires some discussion of the quoted material by the quoting material. But I think also that that is not necessary as regards ordinary understandings of the word quotation. Think of dictionaries of quotation. Dictionaries of quotations. They organise tens of thousands of quotations. They are quotations. There is no discussion of the quotations. There is no textual consideration of the correctness or incorrectness. We understand the term quotation to be being used in its ordinary sense to describe those fragments of text that are being used in a dictionary of quotations. So I think as a matter of ordinary meaning, none of these things are required for something to be a quotation. So I have no problem with understanding Shepard's Fairey's reuse here as a quotation in the general sense. Maybe not in the specific textual type sense, but in the general sense, yes. So then the question is it proportionate to his purpose? Well, Jane said he has an artistic purpose and perhaps a little political purpose. I sense in this picture an intention to emphasize through the picture without the flag Obama's patriotism. Also, clearly we've got the message of hope there, etc. So there is some political purpose and then also some clear artistic purpose. And it's difficult to think how that could be disproportionate to those purposes that the artist has set for themselves. So I think that is unproblematic, and I think that would be relatively unproblematic under 3 of the fair use doctrine.
Well, Part 3, Factor 3 says the amount and substantiality of the portion used in relation to the copyrighted work as a whole. That did raise the question whether it was not only implicit but explicit in the Copyright Act, portion used, that you can't use the whole thing. Right? That portion implies that you're using a part of the underlying work in your new work. But the courts have overcome that reading of the statute and therefore have found that taking the whole of a work may still be fair use if it is consonant with the purpose. So if the purpose is a transformative purpose and you need the whole thing, then it's not disqualifying that you take the whole thing. So if we go back to the image, right, let's say that image is the whole image. In fact, that image is part of a larger image, but I think Garcia also cropped it and disseminated it just as that. Poses an interesting question of what's the work, but assume that the work is just that and not the larger image from the press conference. In that case, Shepard Fairey did take everything except the flag, although one could say that the flag is kind of implicit in the color scheme, and also the diagonals from the flag are kind of reiterated in the Shepard Fairey version. So he took pretty close to the whole thing. That doesn't mean that it's not fair use.
Okay. So the final 2 things that you need to consider in the UK are whether this is, so if you accept that it's fair and proportionate, as quotation and it's proportionate, then you need to assess whether it's fair. And actually we don't have that much jurisprudence on fairness, and we have no jurisprudence on fairness in relation to the quotation exception because it's new. Under the old fair dealing exceptions, the courts would say things like, for whether they're worth saying, I don't know, something is fair if a fair-minded and honest person would regard the dealing as fair. And then they look at the amount taken, the amount added. Transformation would be a consideration, but I think less dominant than in US jurisprudence. They look at the purpose of the use, whether it's a commercial use, and this is probably emphasized, I think, a bit more in English jurisprudence than in the US, and they look at the damage to the market and the motives of the defendant. I think, this is on fairness would be a close call, and I think it would be a close call in the United States. I think probably the transformative quality would be significant, but not as significant as in the US here. And I don't know whether you call this a commercial use.
Well, the original use for the political posters, not, but then Ferry merchandised that image on T-shirts, coffee mugs, sweatshirts, a whole lot of stuff, which does raise a commerciality question. And even though a T-shirt can be a medium of communication and have a certain First Amendment status in the United States, it's still, I think, harder when you've gone beyond a vehicle which is a traditional speech vehicle to something that's also an article of commerce.
So I think that apart from points of real nuance here, UK law has ended up in the same place as US law, apart from the attribution requirement. So it is a formal requirement for the fair quotation defence that the source be attributed unless this is impossible. And by the source, the statute indicates the author of the work and the title of the work. Now, if, it's a bit complicated, but if the name was not on the source photograph, if Manny Garcia's name was not on the AP photograph from which Shepard Fairey took it, that would be an excuse for not attributing under the European interpretation of this provision in the Painter case. And I think that the AP general rules of licensing don't require attribution, since I was looking at them before this seminar, but only glancing at them. So
they generally are attributed.
Are they generally attributed?
But the problem is, and it's endemic, that the photograph, if you went to the AP's website, would be attributed. But those photographs get right-clicked and circulated, and the identifying information disappears. So I think it's a reasonable question for the attribution obligation, whether it suffices to do what Shepard Fairey did, which was just troll the internet, see a picture he liked, and didn't ask any further questions and just took it, or whether, since it's not impossible to find out the source of the photograph, whether some effort has to be made to find out the source of the photograph. Does the author bear the burden of other people stripping out the identifying information, or should it be up to the user to make an effort to find out who the author is?
Okay, so I think that's a good question, and I think in the EU it might be that we would revisit the categorical nature of the statements in Painter. I don't think that that's a dead issue just because it was not on the source. Mm-hmm. I can see scope for some argument there. There's a different way in which it can be justified not to attribute, and that's if it's impossible as a result of the medium in which you're using it. And so then the question would be, if you're using it on political posters, is it impossible to sensibly attribute in that context? And I could see an argument that political messages have to be clear, and that adding the extra material, saying something like after Manny Garcia, might actually be impractical in that kind of a context. And certainly in the context of attribution rights, the British legislature has been willing to treat, for example, in relation to songs played at nightclubs, there's no requirement of attribution where a song is played at a nightclub, and that's a statutory provision, but it reflects this idea that there are certain forms of use where it's impractical to require attribution. The more interesting question that this raises, though, rather than what is impossibility, is what is the effect of non-fulfillment of this condition on the operation of the defence? Because the AP here is suing Shepard Fairey.
Well, they're not. Secretary is suing them, but.
So, all right, yeah. CIPIL is, so that actually might matter, but imagine the AP was suing CIPIL. It's the AP, not Manny Garcia. So what is the role of this attribution condition? Does it mean that the economic rights of AP are being infringed? Or is it actually to be understood as simply saying that the exception that allows quotation is without prejudice to the author's attribution right? If it's without prejudice to the author's attribution right, that means that Manny Garcia can sue and say, my name should be on there, but the AP can't. And I think there's room for a bit of interesting debates around how attribution as a condition of an exception to economic rights infringement operates.
But doesn't 10.3 also say the source has to be named?
So we can't go and see it because I haven't got it here. Yeah, I think, but I don't think by source it means AP. I think that's always been understood, I think, as meaning the title of the work and the authorship rather than the
publisher
direct source from which the person got the work. Yeah. Okay.
All right. So, relatively hot news. The Google Books case, which was decided a couple of weeks ago in the Second Circuit. You probably know the basic facts that in cooperation with the University of Michigan Library, Google scanned millions of books, many millions of which were still in copyright. Google had partnered with other university libraries in the United States, I think also in the UK, to scan their collections, but those libraries limited Google to the public domain materials. Only the University of Michigan let Google scan everything. And having scanned these books, the digital copy was stored permanently in Google's databases, and that was the input. So complete copies of these books stored permanently at wherever Google's server or storage facilities are located. With respect to what the public gets access to, that is far more limited. The public does not get access to the full contents of these materials if they are in copyright and if permission has not been given, because Google has in fact negotiated with many publishers to license the dissemination, the communication of full pages or up to 20% of the book or various formulae. All of that is done under license. So if you do a Google book search and you get any usable amount of content, that's under agreement with the publishers. But where Google did not, if Google did not get permission, the output was much more limited. Those books, the unauthorized books, as well as the public domain books and the authorized books, were all available for search for purposes of data mining, so that any member of the public could query the corpus of books to find out how many times a particular word appeared in whatever the time period requested was, and you would get a search report that gives you the titles of the books and the reference to where the word appears, but you don't get a picture of the page. You just get that information about the occurrence of the search term in the books in the database. So there's no authorial expression communicated from the data mining uses. The other use, the so-called snippet view, allows the user to see the searched word in context of generally 2 or 3 lines. So you will see something that looks like a shard of paper ripped from the book with the line above, the line with the word highlighted, and the line below. So that will let you see in context how the word appears, and supposedly will give you information sufficient to know whether or not the book is relevant. Then you go to the library, you buy the book, but Google is not going to deliver you the whole book unless Google has a license to do so. So that was the output, the snippets and the data mining. A lawsuit was initiated in 2005 by a class of authors and a group of publishers. Years went by with intense negotiations for a settlement, which would have produced a lot of interesting and probably beneficial outcomes. It's just that it had the not so beneficial outcome is that it would have given Google total market power over mass digitization and communication of contents of digital works, and the settlement was ultimately rejected by the courts after objections from the EU, objections from the United States Justice Department. So the settlement died. The publishers then made a separate settlement with Google. The authors persisted with their action. By the time the case was decided by the district court in November 2014, this is now 10 years after Google had started its program, Google had amassed this fabulously useful tool. And I think the district judge was a bit dazzled by how wonderful Google Book Search is. And one might say that the rigor of the fair use analysis was perhaps not as tight as it might have been, because the overall message was, this is such a great thing, how could it not be fair use? That's kind of the unwritten fair use doctrine. That's the fifth factor that's not in the statute. The Second Circuit affirmed, but I think in a much more carefully written opinion. The Second Circuit held that when it comes to the outputs, that is the data mining and the snippet views, there's no infringement, either because the data mining does not communicate any expression to the user, right? All you get is that kind of bean counting information. And as far as the snippet view goes, it is truly minimal. Google has structured it so that you cannot, by repeated queries, reconstruct the page. They've sort of figured out that people might try to do that, so they won't let you do that. And therefore, in one case, there's no infringing output at all. In the second case, there's an output of expression, but it doesn't compete with any actual or potential licensing market, because there's just not enough there. The court was careful to say that this was with respect to the snippet views as presently constituted. In other words, if Google tries to push the envelope by adding a few more lines, maybe that won't be fair use, because maybe that starts to look substitutional. I think the court was concerned with the slippery slope effect, that you lay your marker down and you get 3 lines, so that now we'll move to 5 lines, and then we'll move to 10 lines, and you can see where this might go. So I think the court was trying to fend that off by emphasizing that we're talking about the way the program is currently structured only. Well, I think most people would have acknowledged that the outputs were not going to be considered to be infringing for the reasons we've seen. But there was a big difference of opinion about the inputs, and I think that you'll see this when we turn to Lionel's analysis of the same question, which is even if there is no expression or hardly any expression communicated, Google has made complete copies of these works, which it is storing permanently in its database. In previous cases involving complete copies, so-called intermediate copies, usually a copy was made for the purpose of generating a new work, and then the intermediate copy disappeared. So the classic case would be reverse engineering of a computer program. You want to create a computer program that builds on or possibly competes with the target program. But to study the target program, you have to get access to the source code. The source code is kept secret, so you decompile or recompile the object code, and then you study that in order to figure out how do you write your program, and then you write your program, so your output is totally non-infringing, and you've and the intermediate copy that you created in order to create the output, you now get rid of because you're not exploiting that intermediate copy. And courts have said that that's fair use. Trouble with Google is it's not an intermediate copy; it's a permanent copy. Google is not copying all these works in order to generate some new work. The outputs, in fact, are generated by the users querying the database, not Google building on this material that it has copied. And moreover, it's not a disappearing intermediate copy. Google, however, says our purpose here is to allow for data mining and snippet views, and it is necessary to that purpose to copy the entire work and keep the entire work in the database because the queries are dynamic. You have to keep going back to the full corpus in the database. We can't freeze it at any particular moment in time. And the court agreed that because the permanent full copy was necessary to the purpose of permitting these outputs, and the outputs were non-infringing or the outputs were fair use, then the necessary input becomes fair use too. So the input is bootstrapped to the output, even though it's a complete copy permanently stored by a commercial entity and is also being used for internal commercial purposes by that commercial entity, and the commercial entity is not creating a new work of its own. The outputs are the result of the queries by the users, not by Google. This is a far cry from where we started with fair use, where we talk about borrowing a portion of a work in order to create a new work. Right? Now, there's no new work. Right? Nonetheless, the court says that this is transformative because we've completely transformed the books have been transformed from expressive works of authorship into a collection of data, and they're being queried for their data feature, not for their expressive feature. The court distinguished between information about the book, that doesn't come under anybody's copyright control, and the communication of expression. But what Google, as presently constituted, is mostly doing is generating information about the book. So the work has been disaggregated or disintegrated into all these word data, and that is a transformative use. The court found that there was no market for the snippets. The snippets didn't threaten any market of the publishers, and although now the court didn't go this far, but do I have it? That's a later slide. As to the impact of this ruling on data mining, we'll wait to the end. So as you can see, we've traveled a very long way from putting manacles upon science to Google Books.
So how would Google Books be handled under the quotation exception? Well, as Jane, I think, has already foreshadowed, I think that quotation is a very broad concept, that there are very few necessary conditions to something being a quotation, but something must be conceivably described, but for an act to count as quotation, it must be conceivably capable of being described as quotation. And so when you think about the Google scanning and indexing, where there is no expressive purpose, where they are...
So now you're talking about the inputs, not the outputs.
The inputs, yeah, the inputs. The scanning and indexing of whole works into the digital library. There is no expressive purpose. The act is essentially private. They are scanning over and over again the whole works. Nothing is added to those works. There is no reference back to previous works, and there is no quoting work, even though I would say that none of those things are necessary conditions for the existence of a quotation, I would say that this is a kind of activity that it seems inconceivable that we could describe as quotation, because it lacks so many of the features that we normally associate with quotation. So it seems to me that the actual act of scanning and indexing them requires some other defense if it is going to be able to be legitimate. In contrast, snippets are more tricky, because snippets look and smell quite a lot like quotations. They are short fragments of text that are generated, so they look like the quotations in dictionaries of quotations, apart from the fact that the beginning and ends of these fragments of text are completely arbitrary. But one question that does arise is whether quotation as an act is an intentional or deliberate act. And if so, whose intention could be relevant. And one of the difficulties, if intention or deliberateness to quote is a characteristic of quotation, and if we think just about all non-technological uses of works that we would describe as quotations, they are deliberate or intentional acts, then whose intention is relevant? And the problem is that Google is just setting up a system that generates quotes in response to search terms. So even though these snippets look and smell like quotations, it's difficult to say that Google is quoting the text because there is just an automated system with no intention. In response to that, then, I would try and argue that there is no intention or deliberateness requirement to something being a quotation. I do so not by reference to the ordinary language, but by reference to legal policy. I mean, there is some ordinary language use which talks about unintentional quotation, but it tends to be in the context of postmodernist literature that sees all acts of speaking or communication as themselves generated by a body of prior works that speak through the subject as a kind of agent, and therefore see all works as tissues of quotations, unintentional or intentional. But aside from that use, which I think was probably not in the minds of the drafters of the Berne Convention in 1967, there are legal reasons for thinking intention or deliberateness can't be a requirement for something to be a quotation. And I'll just mention two interrelated ones. And the first is that intention or deliberateness is not a requirement for infringement of copyright. And the reason for that, or one reason for that, is because questions of intention and deliberateness are just very, very difficult questions for the law to deal with. And so it might be said that intention or deliberateness ought not to be a requirement for a defendant because they're equally difficult to deal with. You want your defences to be identifiable as there or not there by reference to the context, how something is used, not the subjective intention of any individual actor. So this isn't, and we were debating this last night, a matter of just symmetry between infringement and exceptions. It's actually a matter of the sorts of inquiries the legal system in a copyright field wants to be engaging with. And the second argument that intention is not a criterion for quotation is that it would be a bit perverse. That if I quote 12 words intentionally, I have the benefit of the quotation exception. But if I just remember them and think I'm speaking them anew, even though I heard them sometime previously, it would be a bit perverse to not say that was quotation, particularly if it was recognised by recipients as being a quotation. So if I, for example, we could think of all sorts of psychological forms where I might have no memory of the source, but I might be thinking that I am saying something new, but in fact everybody else would recognise it as a quotation. So for that reason, because it would be perverse for the law to say that that is not a defensible quotation, whereas an intentional use of exactly the same words is, that's the second reason why I think intention might not be a requirement of quotation. Yeah. And thus that Google might be said to be quoting when it generates these fragments.
So let's go back to the symmetry argument. I think it poses a potential conundrum, at least with the arguments that Google and other technology entrepreneurs have made in the context of the first question, which is there an infringing act, and who commits the infringing act? Because it has been argued with respect to automated systems for reproducing or communicating to the public that respond to on-demand requests by the user. The argument has been that copyright infringement, at least in the US, does not require intent. Right? We have a well-established doctrine of unconscious infringement, which gets to your second point. So you heard a song, so a very famous George Harrison case. Yeah. George Harrison heard a song by a R&B girl group called the Chiffons, which was a great hit in 1963, 1964, called He's So Fine. It was at the top of the charts in the UK. In 1970, George Harrison releases a song called My Sweet Lord, which is He's So Fine. It's just that He's So Fine is got an R&B affect, and My Sweet Lord has a Hare Krishna affect, but it's the same song. And Harrison ultimately acknowledged on the witness stand that this song was the result of his kind of buried memory of the R&B song, and so the court said infringement intent is not an element of infringement. So maybe we'll take this into account in assessing damages, but as to whether or not you have committed an act of infringement, yes, you have, even though you didn't mean to. But our courts have distinguished intent from what they call volition. Right? George Harrison didn't intend to copy a prior song, but he did intend to create a song. Right? So there's and the volition element has come up in the technology cases where the entrepreneurs have said, we just put into place a system. We make no specific choices as to outputs. The user wants to view a certain program or receive some work. We are not the people. There is no the person who is doing the copying is not us. The person, even though it's our equipment that is doing the copying, the person that is doing the copying is the user that requests that we make the copy for the user. Because the we make the copy doesn't really count because that's just automated. Right? Yeah. So if you take that approach, it seems to me that you cannot on the one hand say we don't make the copies, but on the other hand say we do make the quotes. Right? It's pretty much right. So if you want symmetry, you can't have it both ways.
Yeah, so then maybe they have to argue that it's the searchers who make the quotes.
Mm-hmm. And therefore, but if it's the searchers who make the quotes, then we've got, what's the relationship then between the inputs and the outputs?
Well, the question then is whether they get some other sort of immunity. Mm-hmm. By virtue of them not being conscious participants in this.
Anyway, moving on.
Yeah. So I'll skip that because we're going on much too long. If there is a quotation here, the question then arises as to whether there's a possibility that Google could argue that the scanning and indexing is justified as a necessary condition for providing those quotations. Mm-hmm. And Jane mentioned this in the context of arguments about intermediate copying in the United States. We have some arguments of that sort in UK law, but in circumstances where the nexus between the act and the intermediate process is much closer. And I actually just don't think that's going to run. So in Time Warner and Channel 4, there was some copying on the way to taking extracts from a film for use for purposes of criticism or review in a TV broadcast. And there were these acts where a video disc was converted into a beta tape that would allow it then to be shown on British TV with the technologies at the time. Those intermediate acts, at least according to one of the judges, were forgivable because the end purpose was forgivable. But there's a very close nexus, a chain of transactions there towards the purpose. Whereas in the Google scenario, the relationship between each individual quote and the prior system is just much less close. So I think it's going to be hard in the UK to bootstrap the copying of the books into the digital library on the basis of the ultimate legitimacy of the quotations. So that brings us
finally to data mining. Right. So remember that in Google Books, the court held that data mining was simply the provision of information about the book and not the expression of the book. So not copyright infringement. There's certainly no copyright infringement by the users. And on the bootstrap theory, the creation of the database is necessary to perform non-infringing acts. So the creation and retention of the database is okay too. One might say, but wait a minute, there is a problem with interference with competing with markets, because publishers actually do license their works for creation of databases for purposes of text and data mining. And apparently that's done quite a bit in the EU, and I imagine it's maybe done in the United States as well. So isn't there a factor 4 problem with saying that that Google gets to make this database for free when publishers are licensing and some other database providers are paying to create these databases? But I think that the answer, which wasn't asked, so this is just speculating about what might happen in another case, would be to say that if the ultimate acts are not infringing, the fact that the publishers are granting licenses doesn't mean that they can prevent other people from acquiring this same data without permission from the publishers of the books, any more than, for example, the practice of some entertainment magnates in the United States to take licenses to make parodies creates a market for parodies that copyright holders can control. The Supreme Court is rather clearly, in that Pretty Woman case, Campbell against Jacobs-Rove, has said that as a normative matter, there is no market for parody. Copyright owners cannot control the market for making fun of themselves, of making fun of them. So even if Weird Al Yankovic or some others take licenses for whatever reasons to make parodies, that doesn't, the existence of this market doesn't count. So therefore, it's not relevant to fair use that this market that doesn't count might be being competed with by the putative fair user. Well, by the same token, if you say information about the book is not a copyright market, then it shouldn't matter that that some publishers may be granting and some entrepreneurs may be taking licenses for the creation of databases for the purpose of text and data mining. At least so long as the outputs from those databases are limited to information about the book. If they give you, let us say, a premium content, so it's information about the book plus some expression, then you would need a license. But if it's just giving you the bean counting stuff, then I don't think that you would need a license. And the difference between the US and the EU on this may be, although I'm not sure we're in agreement here, that in the EU you do have the database directive that creates a sui generis right protecting the commercial value of material that isn't copyrightable expression. It's a fair question whether or not a book or a library of books is a database in the sense of the directive. But there is at least some basis, I think, for recognizing markets in material that is not copyrightable expression. Whereas I think a potential consequence of Google Books could be that it effectively destroys the market for the creation, at least under the aegis of copyright, for the creation of databases for the purposes of text and data mining.
Okay, so I won't address the database right question. Anybody who wants to know my views can find out afterwards. I think there are significant problems with the notion of substantial investment, but I also think that the database, we will hear more about the database right over the next 10 years. It will come back to be probably a more significant right than it's been since the fixtures marketing decisions. In the UK, I think that there are two aspects to the data mining problem. One is the creation of copies that are made either in the process of mining or to facilitate mining. And in relation to that, we have a specific defence now in section 29A of the Act, introduced in response to the Hargreave reviews, but limited to circumstances where the data mining, the computational analysis, is for a non-commercial purpose. So if copies are made in the process of data mining for a commercial purpose, I think the implication is that that's infringing, and that the quote, even with my very broad interpretation of the quotation right, it's not going to be of any help, given what I've just said about Google Books a moment ago. With respect to the outputs of data mining, however, once the computational analysis has been done, there are 2 points. One is that insofar as these are mere facts that are being data mined, they are unprotected by copyright, and it's perfectly legitimate to exploit those in whatever ways the data miner sees as appropriate, subject to arguments about the database right, but I really don't. I mean, we would need just very specific factual situations to debate that in a sensible way. But one thing that data miners might want to do is extract snippets of material and post them online. And in those circumstances, it seems to me that they might well be involved in acts that we can call quotation, and which is fair for the purposes of quotation. So the quotation right does come back in, at least at the end of data mining, to allow some level of exploitation of that product, but subject to the conditions of fairness, proportionality, and attribution. So I think that's what I say there, and I think that you'll be glad to hear after 1.5 hours, 1 3/4 hours.
No, my watch is past.
Oh, is it?
1.5 hours.
1.5 hours. is all we have to say on this issue, which actually is not true.
We ended up not fighting. So.
I didn't think we would fight. I was surprised you thought we were going to have a fight. But we're happy to take questions, but also I really think you should have a drink, or certainly, yeah.
You can drink and ask questions
Yeah,
at
you
the
could
same
drink
time.
and ask questions at the same time.